Hello, welcome to today's video lecture. My name is Onyekachukwu. I'm a graduate of the Nigerian Law School and a virtual intern at HARLEM Solicitors. Today I'll be speaking on the interconnection policy for telecommunications network providers in Nigeria, protecting public interest. I'll cover what interconnection is, the regulatory framework for interconnection in Nigeria. I'll also cover situations where interconnection may not be possible and NCC's obligation for telecommunication network providers to interconnect. I'll consider the interconnection agreement and then disconnection and termination of interconnection agreements. So let's get to it. Interconnection is a technical and commercial arrangement between telecommunication network providers in which the subscribers of one telecommunication network are enabled to access the services, the network, and equipment of another telecommunication network provider. Let's bring it home. Before an MTN subscriber can make calls to a Glo subscriber, interconnection has to happen. Before an Airtel subscriber can send messages to a 9Mobile subscriber, interconnection has to happen. So interconnection is that linking. So you see that it saves you the stress of buying different SIM lines to be able to access people using those SIM lines. It prevents the monopolistic tendencies of telecommunication networks too. And as part of the objectives of the NCC, Nigerian Communications Commission, contained in Section 1 of the Nigerian Communications Act 2003, we find that the NCC seeks to promote and ensure efficient, adequate communication services in Nigeria. So you see that interconnection is one of those ways. Moving on to the regulatory frameworks for interconnection to take place in Nigeria, we have the NCA 2003, which I mentioned earlier. It is the base, the foundational regulation. In Section 70 of the NCA, the Commission, which is the Nigerian Communications Commission, is empowered to make regulations or subsidiary legislations that will help achieve its objective. So the NCC can make guidelines or regulations to help meet its objectives. Further from that Section 70, which gives it authority, we have the Telecommunications Network Interconnectivity Regulation of 2007, which I might call the TNIR 2007. We also have the Guidelines on Technical Standards for Interconnectivity of Network. And we have the Guidelines on Procedure for Granting Approval for Disconnection of Telecommunication Operators. We also have the Guidelines on International Gateway Access and Voice over Internet Protocol, which is mostly for the international communication, so we won't dwell on it, we'll dwell on the rest. Now, for interconnection to take place, there has to be an interconnection agreement between parties. The NCA provides for interconnection in Part 2, particularly Section 96 to Section 100 of the NCA 2003. And it says that the agreement must be in writing. You know that for a contract to be enforceable, it has to be in writing. So the agreement must be in writing. This agreement will stipulate the terms of use, the interconnection rate. Interconnection rate refers to the costs that will be paid by the requesting party to the requested party for the duration of time which the service was accessed. So it means that when you're making calls from MTN to Airtel, there's an amount that MTN is paying to Airtel for being able to access, for you being able to access their services. That's the interconnection rate. It will make provision for a review clause if necessary. It will make provision for arbitration clause or dispute resolution clause where dispute arises. Now, the NCCA provides that where the parties cannot come to a consensus, it can step in. Or where any party is trying to frustrate negotiation, the NCC can step in. The NCC states that the agreement should promote non-discrimination. The agreement must not be obnoxious to both parties. The agreement must contain equality of access, fair usage. So, as they are in an agreement, the two telecommunication network providers' interests must be protected too. So the NCA is not just protecting the subscriber, it's also protecting the network provider. Now, Section 96 of the NCA 2003 obligates telecommunication network providers to interconnect, meaning where a requesting party, which is the party seeking interconnection, sends interconnection request to the requested party, which is the party from which interconnection is sought. For example, where MTN sends requests to Airtel to interconnect, Airtel cannot just blatantly refuse. The NC obligates Airtel to respond. And in the Telecommunication Network Interconnection Regulation of 2007, it states further that NCC will regard a denial of interconnection request as an anti-competitive practice. So parties, the telecommunication networks, have to interconnect. But there are situations where interconnection may not be possible. For example, where the telecommunication network provider seeking interconnection is not licensed, it won't be possible. Also, where the service for which they are seeking interconnection does not require interconnection will not be possible. Lastly, where there is no point of connection, POI, the interconnection will not be possible. In the 2012 guidelines, it states further that where the services of the interconnection service will affect the property or equipment of the telecom network provider, or will affect the quality of services to be rendered, then interconnection may not be possible. Where there are issues in interconnection, parties may feel like they want to disconnect. But in section 100 of the NCA, parties cannot disconnect unilaterally. They require the written permission of the NCC before disconnection can take place. Now you must understand that disconnection and termination are different. Termination, of course, when the interconnection agreement, the duration contained in the agreement lapses, then termination can take place. But disconnection of interconnection service does not even require lapse. Disconnection can be sought where the requesting party falls into indebtedness, meaning they fail to pay for the interconnection rates as agreed by the parties, then they can seek disconnection. Also, where there is a fundamental breach of the interconnection agreement. For example, as I said, in the agreement they contain policy of usage of information obtained, where a party uses information obtained to do something else outside the interconnection service sought, then there is a fundamental breach. So on that ground, they can seek disconnection. And for any other ground that the NCC may permit, under paragraph 3, sub 1 of the 2012 guidelines on procedure for granting approval for disconnection of telecom operators, 2012 guidelines. Now, for termination to take place, you don't need the NCC's approval. Once your agreement has lapsed, you can terminate it. But for disconnection, you must remember that you require NCC's approval. Now, under the procedure, you find that the complaining party has to write a notice to the NCC and fill a form called the disconnection form 1. When the NCC receives the form, the NCC will conduct inquiries to check if there is actually a case at hand, a case that is worth looking into. And they will conduct investigation into the interconnection service or any part that needs investigation on. They might consider the past indebtedness of the requesting party or the party in debt to be able to give decision whether it should be disconnected or not. And they may grant partial disconnection because, of course, they are protecting your interest. They don't want you to wake up one morning and you can't access somebody all of a sudden. But where the rules necessary are not followed, there may be permanent disconnection as the NCC chooses to determine. Now let's give a brief summary because of time. You must remember that NCC obligates telecommunication network providers to interconnect. You must remember that where they cannot come at an agreement, the NCC can step in, or where somebody is trying to frustrate negotiations, the NCC can step in. You must remember that the use of info should be protected and only for interconnection services. And you must remember that you cannot disconnect interconnection services without express approval from the NCC. I hope you've learned a lot from this video. Don't forget to like and subscribe to HARLEM Solicitors page and look out for more content from HARLEM Solicitors. Thank you very much.